afternoon. Can I get a roll call? Can I get a roll call, please?
Commissioner Bain,
Here.
Commissioner Bush, Commissioner Fuste,
Here.
Commissioner Hellman, Commissioner Lyle,
Here.
Commissioner Rogers,
Here.
Commissioner Lucas,
Here.
Commissioner Stewart.
Here.
We have a quorum present.
I didn't. Did Commissioner Hellman, did he chime in? I didn't hear it.
He was muted, but I see him.
Okay.
Oh, my audio is on. Can you guys hear me now?
Yes.
Yes.
Okay.
Commissioner
Perfect.
Bush, are you with us? Are you able to unmute? There should be a audio button perhaps on the lower left of your screen.
I see his name there. Okay. Yeah, I got my screen reduced so I can get it, so I can get all the stuff in.
I have word Commissioner Bush is with us.
Okay, awesome. Thank you very much. All right, well, it's a perfect segue into this. Since our last meeting, well, first of all, I just hope everybody had a good 4th of July. And kudos to the staff with the long break that you guys got. It was awesome. Give me 1 second, just clear some background noise. I apologize.
Commissioner Bush?
Oh, he's off mute.
We hear you loud and clear now.
Okay, there we go.
This is Commissioner Bush, right?
Yes, sir. We got you. Thank you.
Okay.
All right. Well, since our last meeting, Governor DeSantis appointed 2 new members to the commission who are joining us today for the first time. Please join me in welcoming Michael Hellman and Jeremy Rogers to the commission.
Congratulations.
Congratulations.
Welcome.
Thank you, guys. Thank you, Mr. Chair.
Thank you, thank you. And looking forward to working with all you. I know Mr. Hellman in passing. I've never worked with him. Unfortunately, I'm old enough to have worked with his father a long time ago. So it's just the reality. It's the reality of life. Anyways, we look forward to seeing you guys in person next. I think it's our next week or in 2 weeks in Tallahassee. Kind of dates are all jumbled for me. I'd like some preliminary announcements just because we're on Zoom right now. Please mute your mics unless you are speaking, and keep your video on for the duration of the meeting. Please silence your cell phones as notifications can be disruptive to the live feed. I'm going to start with item consideration of financial disclosure appeal. Commissioners, I called this special meeting because the District Court of Appeal granted the commission 30 days of concurrent jurisdiction to rule on a financial disclosure appeal that was filed simultaneously with an appellant filing an appeal of the default final order the commission entered in its last meeting. You have been provided with materials for this meeting that include the financial disclosure appeal, the draft final order for the appeal, as well as the relevant filings before the court. At this time, I'll recognize our Assistant General Counsel, Mr. Graydon Schaefer, to present the appeal and explain the special procedural history on this matter.
Thank you, Chair. Can you all hear me? Okay.
Yeah.
As the chair said, the background on this appeal is somewhat unique. It's traveled kind of an unusual road to get before you all today. But the good news is the legal analysis here, I think, is fairly straightforward. So I'd first like to go through the procedural history of this matter for you and, again, kind of trace the steps of why we're here today. And then I'll move on to discuss the merits of whether or not we're recommending that this disclosure fine be waived. The appellant here, and I think the appellant, by the way, is watching from the gallery, He's the former Water Resources Coordinator for Palm Beach County. That position carries a Form 1 filing requirement. And he served as a county employee from September of 2018 to March of 2022, and he filed the Form 1 for each of those years. Unfortunately, he didn't timely file his 2021 Form 1 by its due date, which was July 1st of 2022. Now, as you know, after the deadline, there's a 60-day penalty-free grace period during which a filer can file without incurring any type of monetary penalty. Regarding the 2021 form, that grace period ran from July 1st to September 1st of 2022, but he also did not file that form during that 60-day grace period. So once the grace period expired, he started to accrue under the statute a $25 a day fine, and ultimately he accrued the maximum fine allowed by the statute, which was $1,500, and it's that $1,500 fine that is now the subject of this appeal. Now, when it comes to disclosure appeals, your legal staff always looks to make sure that the filer has received notice of their filing obligation for a particular form year before they start to accrue a fine, which happens again when the grace period expires. Now, as you can see in your meeting materials, there were 3 notices sent to the appellant before the grace period expired, before he would start to accrue a fine. There was first a initial notice from the Palm Beach County Supervisor of Elections. Then there was a notice from the supervisor that was sent certified mail. And then there was a reminder postcard from the Ethics Commission. All of those notices were sent before the grace period expired, before September 1st of 2022. They were all sent to the appellant's work address, which is a Palm Beach County government building. It's located at 301 North Olive Avenue in West Palm Beach. So like I said, 3 notices were sent. Then the grace period expired, and he began to accrue this $25 a day fine, which eventually totaled $1,500. At that point, because he had still not filed his 2021 Form 1, the commission sent him a notice of assessment of automatic fine. Now, that notice of assessment indicated the total amount of the fine that would be imposed against him, which was $1,500. It also included his notification of appellate rights. It gave him, I believe it was 30 days under the statute, to challenge that $1,500 fine through our appeal process. That notice of assessment of fine containing the appellate rights was sent to the appellant at the same county address, and he did not file an appeal within that 30-day appellate window. So because of that, earlier this year, as you heard the chair say, the commission entered a default order against him imposing that $1,500 fine. Now, this is where things get interesting. The default order was delivered to that same county building address, and apparently a kind-hearted county employee passed it along at that point to the appellant. Now, once he received the default order, he did 2 things almost simultaneously. First, he filed an appeal of the default order, imposing that $1,500 fine, with the appellate court here in Tallahassee, with the First District Court of Appeal. And second, he filed an internal financial disclosure appeal with us here at the commission, asking that the commission rescind the default order and waive his fine. Now, in both the appeal at the district court and in the internal disclosure appeal here at the commission, his argument is the same. Okay, he claims he didn't receive timely notice of his filing obligation because he left county employment in March of 2022 before any of the notices about his 2021 filing obligation were sent to him. And he then never received any of the notices because they went to that same county office building and they were not forwarded on to him. And he supports that argument by including his resignation letter from the county and other materials from the county indicating that he did indeed leave county employment in March of 2022. So what we're left with here is kind of unusual. We have an appeal at the district court and an internal administrative appeal here at the commission, both challenging the default order on the grounds of lack of notice. So that's an interesting issue. Under the Florida Rules of Appellate Procedure, the Ethics Commission technically lost jurisdiction over the default order once the appeal was filed at the first district, because obviously the commission can't modify or rescind an order that's the subject of an active appeal. So the commission technically would not be able to process this internal disclosure appeal, at least without getting permission from the appellate court. So a few weeks ago, the appellant and your legal staff filed a joint motion at the First District asking that the court temporarily relinquish jurisdiction over the default order so that we be able to go ahead and process this internal administrative appeal. And our argument was that relinquishing jurisdiction would really serve the purposes of judicial economy, because in the event that the commission finds here there are legitimate lack of notice issues and therefore agrees to rescind the default order and waive the fine, then the matter that the district court could also be dismissed because the default order on appeal would no longer exist. Now, what the First District did is it responded with an order stating it would give us 30 days to share concurrent jurisdiction with it over that default order so that we'd be able to go ahead and process this disclosure appeal. That 30-day window runs until July 16th, which is why we had to hurry up and have this special meeting here today to make sure we hear this disclosure appeal before that time window closes. So if you decide today to rescind the default order and waive the $1,500 fine, and by the way, that's what your staff is recommending, we will then move to dismiss the appeal at the First District. But if you decide to affirm the fine and uphold the default order, then the appeal at the court will really proceed as if nothing had happened. So that's the background here. That's the most complicated part of my presentation, but hopefully that answers any questions you might have from the materials. Now, if you look at the appeal itself, there's two real hurdles we have to cover. First, like I said, the appellant did not timely appeal his disclosure fine within that 30-day window after he received notification of his appellate rights. So first, you have to determine if his untimely appeal should be considered on the merits, whether or not there's reason to treat it as if it were timely filed. Assuming you do decide to consider on the merits, you then have to look at whether or not there's unusual circumstances here that would warrant waiving his fine. The statutes allow you to waive a disclosure fine if the appellant can show unusual circumstances. So turning first to the timeliness issue, I would recommend you treat this appeal as if it were timely, given the fact that the appellant here never received timely notice of his appellate rights. So you can see in your materials, this notice was sent certified mail to the county building in November of 2023. That was about a year and a half after the appellant had left county employment. It was signed for by someone other than the appellant, and then it was sent back to us here at the commission. Because there's no indication here the appellant received timely notice of his need to file the appeal, I would recommend for due process reasons that you treat this appeal on the merits as if it were timely filed. And if you look at the merits of his argument, which again is lack of notice, we have nothing to dispute the claim that he didn't receive notice. All of the notices that were sent to him before the grace period expired and he started to accrue a fine were sent during the summer of 2022. They were sent to a county office building. And as I said, he left county employment the previous March, so he never received any of them. Now, one of those notices was sent certified by the supervisor of elections, but it was signed for by someone at the county other than the appellant, so we have no indication he received it. Now, Commissioners, I know these lack of notice claims were discussed at your June meeting, but I will say I think that this particular matter presents a very sympathetic case. This is not an instance where notices were delivered to a public office building but never made their way up to a public employee's office. This is not an instance where the notices were delivered to a home address but were inadvertently thrown out. Now, this individual never received these notices because he was not present at the address where they were sent. It wasn't his fault. And I'd like to remind you, as recently as your June meeting last month, you waived a fine under identical circumstances. In June, you dealt with a disclosure appeal involving a city employee who had accrued a fine for not filing their Form 1 in a timely manner. That individual, the notices were all sent to his city mailing address, but by that point, he had already left city employment. He never received any of them. And last month, you decided that was unusual circumstances, and you waived his fine. This is the same identical circumstances here. We're just dealing with a county employee instead. So for all those reasons, I would recommend you treat this appeal as if it were timely filed and find there's unusual circumstances that'll warrant rescinding this default order against the appellant and then waiving that $1,500 fine. I present the draft order for your review. I'm happy to answer your questions, and I will remind you again, Mr. McBride, the appellant here is, I believe, in the gallery, so he is listening to this discussion.
Thank you, Mr. Schaefer. Just really quick on, I have it as page 32 of the packet that we were sent. I think it's Mr. McBrien's appeal to at least us. Just want to make sure. So the order was signed or heard on the 25th, signed by myself on the 30th. So in less than 30 days, he filed the appeal with our office, correct?
Yeah, it looks like the order was signed on April 25th. I think he filed the appeal with us on May 12th. Again, my understanding is the time frame was the default order went to that county building address. And at that point, from what we know, it's the first time one of the county employees thought we need to send this on to the appellant. And so as soon as he got that, I believe he called our disclosure staff to clarify what was going on, said it was the first time he'd even realized there was a fine that had accrued, and he filed his form and this appeal. And at the same time, he filed the appeal at the first district.
Anybody have any other questions of Mr. Schaefer?
I think that we need to be consistent, and I do recall that case that we heard and ruled on the last time. So I would recommend that we follow your advice.
So I
Mr.
have
Schaefer,
one
Commissioner, if I may, Mr. Schaefer, I'd like to know what authority we have to consider an untimely appeal as timely.
Sure.
I don't see any citation that gives us authority in the materials, whether it's by statute or rule.
If you look at page 4 to the top of page 5 of the disclosure appeal order, the draft order in front of you, which I think is just page 4 of your meeting materials, it explains that a fundamental requirement of due process is to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. The reason why we occasionally have to bring these matters before you and encourage you to consider them, even if they're untimely, is for due process reasons. And we really only do that when there's no indication that the party has timely received notice of their appellate rights.
Okay, but is there a statute that allows us to treat an untimely appeal as timely?
Well, it's just a fundamental principle of due process.
Right. And just to piggyback on that, Commissioner, just the only thing that would be an issue here would be the jurisdictional issue because it's before the first DCA. I often have this in my own practice. So the fact that the first DCA has allowed us to have concurrent jurisdiction for 30 days, and like Mr. Schaefer says, it's not a statute. It's just built into, the due process, which is applicable to the states through the 14th Amendment. And that's how it comes to bear on us.
Well, there are strict requirements for filing an appeal on time, and it seems like they have not been met here. And I don't see how we have the statutory authority to address the appeal. I understand everything that you said about having concurrent jurisdiction that's been relinquished by the first DCA. That's not the question. It just seems like we have an untimely appeal, and you're now trying to somehow bootstrap jurisdiction where it doesn't seem like we have any.
Again, I would just say that this is based on principles of due process. My concern would be if you affirm the fine here on the grounds that the appeal was untimely, and then on appeal, he's able to show the appellate court that he never received timely notice of his appellate rights, that he never received the notification through no fault of his own, that he had only 30 days to appeal. I'm afraid the court's going to reverse this on just general due process grounds.
I don't see how he didn't have notice when he was an employee for years prior and had actual notice and as well as constructive notice of the requirement from prior actions. But that's another issue altogether. Go ahead.
Mr. Chair, I'd like to follow up on that if I can.
Go ahead.
Thank you. Mr. Schaefer, I mean, it seems to me like you're very broadly reading or interpreting what due process requirements are. And I would suggest it's not actual receipt of the notice. If the agency has gone through steps that should have allowed the recipient to have received the notice, even though they didn't, I don't know that's a due process issue. And so if the only authority that you're giving us is the constitutional authority and sort of the overall statements, you cited the well-known Mullane versus Central Hanover Bank case for the due process. If there's nothing more specific than that, either a rule that governs this body or a state statute, which of course govern this body, I'm certainly in line with Commissioner Bain on this. I don't see how you get by the untimely appeal issue. And then follow up on one more thing Commissioner Bain said, and that is that this person timely filed for years, multiple years. And the fact that he says he forgot about it, I'm not sure what we have in terms of any proof. You've also, Mr. Schaefer said rather authoritatively that that was the first time that a well-intended public employee forwarded on. Well, you don't know that to be the case. Everyone previously might have been forwarded on. So again, I'm aligned with Commissioner Bain on this, and I don't see how we get by the untimely appeal issue. Thank you, Mr.
No, thank you, Commissioner. So right now I have a motion on the floor to go with the staff recommendation.
Recommendation.
Do I have a second?
Second.
Second.
All right. I think we're gonna need a roll call on this. If I can get a roll call.
Mr. Chair, can we have some discussion first?
I apologize. Go ahead. I apologize. Go ahead, Commissioner.
Hey, sorry. Thanks, Mr. Chair. First time I'm speaking. So thank you to the Governor, Governor DeSantis, for appointing me, and colleagues. Look forward to seeing you in person. Couple questions. Just want to make sure I've got everything on this. Mr. Schaefer, you said this is similar to the June. I think it's slightly different though, in that in the June ones, and I went and watched some of these before coming on. We have the similar notice, but this one you've got the additional complexity of the appeal as well. Do I have that understanding correct?
That's correct. The matter in June, I believe the individual filed an appeal within the 30-day appellate window. So I believe it was a timely appeal. When I said it was similar to it, all I meant was that the argument of lack of notice, based on the fact that the notifications went to a public office address where he was no longer working, that's where I'm drawing a similarity.
That makes sense. And Mr. Chair, for staff as well, I see in our packet the individual has filed his 2020, this is 2021, right, that we're talking about. He filed this shortly after he claims he got it, right? It's now filed and on the record.
That is correct. If I neglected to mention that, I'm sorry. He has filed his Form 1 for 2021. That is on file.
Awesome. Another question, Mr. Chair, for General Counsel. I see you hand just went up. I know in the June meeting, you had indicated that at least previous commissions had kind of given you the goal, the goal is to get filing, not to be punitive. I wasn't on the commission then. Can you just rehash that statement? I'd like to hear that again.
Sure. And welcome to the commission, Commissioner. What we were talking about last time at the last meeting was like, what are we trying to do here with these processes, these appeals, and so forth. And the overwhelming goal here is to afford the public the transparency that they're entitled to by getting these forms filed so the public can review it and monitor their public officers and public employees for potential conflicts or other things that might be of interest to them, like whether or not they want to vote in a particular way or not, et cetera. These forms allow the public a lot of information, and we are trying to just get these forms in. And a lot of the people that are required to file these forms, they're volunteer on local boards, the local Parks and Rec board or something like that. A lot of them are public employees. A few of them are public officers and and elected officials. And so overall, there's about 40,000 people that file these forms. There's a lot of forms that need to get filed. What our overwhelming concern has been is to get the forms into this office. The fines are a mechanism to certainly encourage people to do that. But where the issue has been, did they or did they not get notice that they were supposed to file in the first place? The commission has taken the arguments that if they didn't get the notice, we're going to waive that fine. That's been in the past. And, the staff is kind of taken from that. What we're trying to do is get the form in the first place and not argue about the $25 a day. That being said, there was one other thing that did come up. I did want to bring up about where does the 30 days for the appeal come from and so forth. That's in both both the statute and the rule. In the statute, what it says is that the filer may file a request in writing to be received by the commission within 30 days of the notice of payment due is transmitted. What Gray is talking about here is that we transmitted the notice, but we transmitted it essentially into the ether. We sent it to an address where the person wasn't receiving mail. They weren't working there and hadn't been working there for months. And so that's, where we essentially what we're saying is we didn't transmit it to them such that they would know that the 30 days was ticking and that they had the right to appeal. So without receipt of that notice of appeal, there's a fundamental concept of fairness about having those 30 days tick when they don't even know that they're ticking. And so that's what we're talking about here, to consider it timely because they didn't know that the clock was ticking on the appeal.
Commissioner, if I may.
Go ahead, Commissioner.
I appreciate what you're saying, and I don't doubt, as Commissioner Stewart says, that if we were dealing with a timely appeal, that we would probably be compelled to rule the same way as we did last month. But we are dealing with an untimely appeal, and when you fail to file an appeal in a timely fashion, we've lost jurisdiction. So I don't see how we have jurisdiction to address an untimely appeal, and I don't see a statute or rule that gives us jurisdiction over an untimely appeal. And with reference to Mr. Schaefer's citation of a case law, the case law doesn't confer jurisdiction. We have to have jurisdiction specifically conferred upon us by a statute or a rule. And it seems like we've lost that jurisdiction here. Now, maybe the First District Court of Appeal will say that we never lose jurisdiction, but it seems like that we're ultra vires to somehow rule that we have jurisdiction over something that the statute or rule does not give us jurisdiction over at this point.
Okay, thank you very much. Any other comments, questions? Commissioner Lucas, do you have a question?
Yeah, my only comment is that the failure to timely appeal being jurisdictional, I think, is a function of the Florida Rules of Appellate Procedure, and I don't think that's what's governing us. I think that we're operating outside of those cases that hold that. So I would be in favor of the motion on the floor.
Okay, thank you very much. Commissioner Lyle, do you have another comment?
I do, thank you. General Counsel, what was that statutory reference you were referring to?
Yes, sir. Let me scroll up here just so that I can. We are in section 112.3145, subsection 8, F2.
And the requirement that places on the commission is one of transmission.
That's correct. We are to transmit the appeal, and then once transmission has been effectuated, the filer has 30 days to become an appellant.
And a textualist would say that transmit means one thing and receive means something else. And the legislature has in other areas started time periods running from received. You mentioned that the address, something about the ether, but the address the commission sent the notice to was the last address that the filer had provided to the commission, correct?
My understanding is that is correct. What he doesn't have, though, is an obligation to update the address with us in between filing years. And so
and arguably when he fails to do that, he also gives up any additional due process because he knows that the commission will be sending him things or has reason to expect that. So anyway, I continue to be opposed to the motion. Thank you.
All right, thank you, Commissioner Lyle. Commissioner Rogers, is that your hand up or is that from before?
Yeah, no, thanks, Mr. Chair. One more question, then probably a comment from me. For General Counsel, I'm sorry, General Counsel, how do you say your last name?
Yes, sir. Just pretend there's no U in it. Zilkowski.
Zilkowski, thank you. Mr. Zilkowski, I know in June, I want to say you commented, and it's my understanding that the address provided, in this case, to the supervisor of elections, which gets passed on to Florida Commission on Ethics, maybe also passed on directly from that's a function maintained generally by what I would call the agency coordinator, in this case, probably Palm Beach County. They have Palm Beach County as a person and maybe a backup who provides the address for every single they identify who has to file and are responsible for providing that, where we send that address, right? Florida Commission on Ethics. Is my understanding correct there?
That is correct. The list, which includes the names and addresses, that's provided to us by the chain of evidence. There would be the coordinator at the agency to the SOE in this case, because that's a local filer. Kerry has more on that, of course, as far as exactly where that goes and what other information is provided at that point.
Mr. Chair, I'd like to hear from our executive director. I do want to comment on how I intend to weigh in, but I want to hear what our executive director has to say since her hand's up.
Go ahead,
Through the
Carrie.
Chair, thank
Go
you.
ahead, Carrie.
I just wanted to point out that with these coordinators, we are dependent upon them, particularly with the paper system, which was what we were dealing with here, to update filers, people who were required to file by law, as well as a good address for those individuals. That update occurs at the beginning of each calendar year for the previous calendar year. So we ask that they get those updates to us by the beginning of February. Sometimes it takes a little bit longer than that. I don't know offhand what date this person left employment, but once that address information is provided to us, we lock down the list from the year before, and those notices start going out to the addresses that were provided to us. Even sometimes if a filer updates their address on their form that they filed with this person, they were a local filer, so it would be filed with the supervisor of elections. That doesn't necessarily update the address information in our database. Of course, that all changed with e-filing, but just wanted to emphasize that we are dependent on the coordinators for providing the correct address for the filer. And ultimately, we do try to find folks when we realize we have a bad address, but that can sometimes be difficult to do.
Right. Thank you, Carrie. Appreciate it. Commissioner Rogers, you have a follow-up on that?
Yeah, Mr. Chair, I just wanted to, for the public and for my colleagues, weigh in. I am comfortable with the recommendation from staff to treat this as timely and to waive the fine. I think we discussed, or not we, but the commission discussed this a lot in June. Clearly there's a difference of opinion among some of the commissioners here. I've been in the spot at both the city and the state level, and I know that workers and even more volunteers get in this spot. And there's, a couple of our commissioners, I think, have weighed in that, well, the commission is doing everything that they should, right? Like, what else is there to do? But we still see this kind of gap of the notice, and all notices get sent to the previous address, and the previous address, which are still government workers and the coordinator there, it kind of that turns into a sinkhole. So I intend to maybe explore this a little further in a future meeting on what we can get the coordinators to do to take a little bit more responsibility in forwarding this on. I mean, clearly the commission and the staff that's working so hard isn't going to be able to keep tabs on 40,000 folks. But I see the coordinators at the sites as kind of the only possibility. It's either the members or the coordinators that really need to pull this together. A few of us here are saying that it's on the members, full stop. I'd like to see what we could do with the coordinators going forward. But for this item, I am comfortable following staff's recommendation. Thank you, Mr. Chair.
Thank you very much. Any more comments from the commissioners?
So I guess I have, Mr. Chair, if I could, the General Counsel, the paragraph there, the section 72 has a sentence that says, for purposes of this subparagraph, the term unusual circumstances does not include the failure to monitor an email account or failure to receive notice if the person has not notified the commission of a change in his or her email address.
Yes.
So that's just with respect to email. That doesn't apply with respect to sort of the old system of paper filings, right?
That's correct. That was added as part of the scheme change to adopt electronic filing. So one of the things that Commissioner Rogers was asking about was how can we address this in the future? That is one of the things that would serve to help address this, is the failure to monitor an email address will not constitute unusual circumstance. The other thing is that with electronic filing, it will be emails that are going to these people. So hopefully we'll have a little bit more of a better delivery mechanism, because the updated email addresses will be in the system. And the people will have, as you've already seen, if you've already filed your Form 6, you've seen that the first thing you were prompted with when you log in year after year is the chance to update your own email address and what you look like when you're on our list. And so that there's a little bit of a participatory aspect to it now that wasn't quite present before.
Thank you.
Steve, appreciate it. Any more comments for? Oh, yes, Commissioner Lucas.
Commissioner, you're muted.
You're muted.
Sorry. Just rounding out my last comment, just because I want to make sure that both sides are fully presented, that we're not operating under the jurisdictional bars of the Florida Rules of Appellate Procedure. I mean, I'm looking at a first CCA case right now in the 120 context that talks about the doctrine of equitable tolling, and it says a late filed petition should be accepted when the plaintiff has been misled or lulled into inaction, has been prevented from asserting his rights, or has timely asserted his rights in the wrong forum. And I mean, that's the doctrine of equitable tolling under Chapter 125(7), which says, and this is a bid protest case, it says the failure to file a notice of protest shall constitute a waiver. And even in that case, the court said, well, equitable tolling can still apply when you have language saying in 120, it shall constitute a waiver. So I think that looking at this as like looking at the equitable lane here, I think makes a lot more sense, since we're a lot closer to the 120 context than we are at the Florida Rules of Appellate Procedure context, which governs. I mean, that's a constitutional jurisdictional requirement. So I see this as more an equitable side of things. This is more in 120 land, and so that is a much more rambling and long-winded way of saying what I was trying to say earlier, which is I don't think it's a jurisdictional bar that it was untimely filed, and I'm still in favor of the motion.
Thank you very much. Okay.
Oops, did I need to do that beforehand?
No, you're
Commissioner
good.
Bush
You're
has
good.
his hand up.
Okay, so without any more
Chairman?
comments, I have a
Mr. Chairman?
first. Yes, go ahead, Commissioner.
Okay,
Yes, Commissioner, go ahead.
Mr. Chairman, okay, Commissioner Bush, I too think that we should take the recommendation of the staff, as well as I consider this as a timely file. And as I stated at our last meeting, I think that due process does matter. And the 3 locations that the notices were sent, the plaintiff did not sign for neither one. And so with that being said, I think that we want to be consistent with the last meeting that we had a similar situation. And I think that we ruled in favor, and I think that we need to be consistent. So with that, I don't have any problems with taking the recommendation or following the recommendation of the staff.
Okay,
Commissioner, if I
thank you
can
very much,
respond to that.
Go ahead, Commissioner.
Thank you, Chair. I agree with Commissioner Bush. Due process does matter. I have a client that lives in Canada, and due process is satisfied when a notice of a lawsuit's filed in a newspaper in Collier County that he never receives. So that's considered due process. What troubles me more than anything here is the statute. And I think that and I think, Gray, you missed an opportunity to argue just how unclear the statute is, because paragraph A of paragraph 8 of the statute that you cited to 112.3145 simply requires the commission to notify anyone required to file financial disclosures in the year of their employment or the year beginning their year of service. There's no continuing obligation anywhere in the statute for that we have to provide notice each and every year, in each and every successive year. The argument can be made under subsection C of paragraph 8 that there's an implied requirement, because subsection C is the one that says if a person holding public office or public employment fails or refuses to file an annual statement of financial interest for any year in which the person received notice from the commission regarding the failure to file, that statement right there implies a continuing obligation on the commission to provide notice each and every year. But I don't see anywhere in the statute that says we have to provide notice each and every year beyond the first year. So he clearly received notice the first year, but because the statute's unclear, I'm inclined to agree that we probably have our hands tied, and we need to get the statute. No offense to our senator here, we need to get the statute clarified, Carrie, and we need to make this a priority for our legislative push, because we're going to continue to these appeals are going to have to continue to be granted as long as we're dealing with an unclear statute, it seems like.
Thank you, Commissioner Bain. And just to piggyback on that, although I do agree that the due process is applicable here only because I've myself used it in similar circumstances as this. I do agree with Commissioner Bain in the sense that we're going to miss an opportunity. We should take advantage of an opportunity to tighten this up. In other words, put the onus on the reporting individual, takes the onus off the commission to continuously notice these people. It's almost like if we don't notice them, they get a free ride. And it almost is like the burden is shifting from their responsibility to fill it out, which is inherent in their job, versus our responsibility to tell them that they didn't fill it out. Almost like a parental role, which I don't really think the commission or the staff should be burdened with. However, in this particular case, I believe due process prevails. And with that, I am ready to take a vote unless anybody has any other comments. Yep. Right, all in favor of accepting the recommendation of staff, say aye.
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 All opposed? Okay, hearing no opposition. I have no opposition. Motion passes unanimously. Thank you very much. Okay, let me see what's next on the agenda. Okay. Now we're off to item number 4, discussion of meeting remote attendance to in-person commission meetings by commission members. Pursuant to section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. The public could provide comment via email prior to today's meeting. I'll ask the commission to briefly unmute the mics if there's any member of the public who would like to be heard on this matter. Please identify yourself at this time. Okay. Commission has not received any comments, so we'll proceed with our meeting. All right, let's move forward on the remote meetings. A member of the commission has requested to attend commission's meeting remotely. Although the commission has held a few public sessions meetings where everyone attended via teleconference, like this one, we have not had meetings where some members attend in person while others attend remotely. This concerns how the commission conducts its meetings. Staff has researched remote meetings and partial remote attendance by members at in-person meetings, and I have the executive director put this on the agenda for discussion today. This matter has appeared on previous meeting agendas and has been briefly discussed. The item was temporarily postponed so that the requesting member could be in attendance. I'll recognize the Commissioner Executive Director to begin our discussion by outlining the options available to the commission before we have our discussion. Carrie, the mic is all yours.
Thank you, Mr. Chair. As mentioned, we're talking about hybrid meetings. I'm going to talk a little bit about some of the things we've noted logistically, and then Steve will talk about the legal requirements of meetings. As you know, with public session meetings, we have to publicly notice them. There are specific requirements as to the type of meeting held, and Steve will talk about that. We have to record audio. It's preferable public session be able to be broadcast so the member of the public and press can observe the commission's consideration of matters. And we do that. We have a live stream of that. We want to make sure that complainants, respondents, and their counsel, as well as others with items on the agenda, are able to fully participate and provide the ability of members of the public to be able to comment on non-quasi-judicial proceedings. As for executive session meetings, we've not had those via a Zoom or a remote as a full commission because the executive session meeting contains matters that are confidential and exempt from public records laws. And so we don't have the ability to assure confidentiality for our respondents in those cases, which is why we can't simply have a remote meeting where we do a public session and then we go into executive session because of that unique challenge with holding confidential sessions. In terms of having some members attend remotely while the commission has an in-person meeting, because we don't have our own dedicated meeting space to outfit with particular technology, we took a look at the meeting space we currently use at the district court, as well as had discussions with IT folks down at the Senate in terms of what our options were. It would appear that if the commission chose to do some hybrid participation, logistically, we might want to invest in some equipment so that we can utilize an OWL or some sort of hub in the courtroom. We have a little bit of a challenge there because we have maxed out the number of microphone jacks that we have the ability to utilize. We might, the path of least resistance would be to utilize some sort of conference call or Zoom for that particular member, which would require putting a mic right in front of that laptop or in front of the conference equipment for just that commissioner, unless we were going to invest in equipment that we would take to and from the court. We also have a sound mixer that we use that also is maxed out currently with the number of inputs that we have. So there could be costs associated with that to do it in a way where the sound quality would be what we needed to have, and in particular be able to patch the members in who are not in attendance. In terms of the Senate, they are equipped in a couple of rooms to do remote meetings with a video board where people participating remotely can be seen. If you watched some of this legislative session's committee meetings, they did have some confirmation hearings where I saw different people phoning in. They did sometimes experience technical issues on the end of those calling in by video or by phone. One particular instance had to use a member's telephone to contact the person and hold that up to a microphone. So there's always going to be technical challenges to that. The other challenge within the Senate is that we are not always first on the list for being able to utilize Senate meeting rooms. There is we will be bumped during session, likely bumped during committee weeks, and could be bumped at other times, but they have been generous in the past with allowing us to use their room otherwise. In that case, if we were in the Senate, it does appear that we would still hold executive session via conference call with whomever we're trying to attend remotely, because as I understand it, to utilize sort of a Zoom technology like we're doing now to patch into the room, that tends to run through the Florida channel, and there's no way, if it's run through the Florida channel, for it not to broadcast. That said, I will turn it over to Steve for a discussion of the legal requirements for meetings, and then await your discussion and direction as to how we should proceed.
Thank you, Madam Executive Director. I'm going to cover some of the logistics of what we do for our meetings, and that'll bleed into the legal requirements, just because we have some new commissioners here, and but we've not done yet boardsmanship orientation yet. So just to give the framework for what it is that we even do. Under normal circumstances, year after year, historically, what we do is about 8 meetings per year, and we send the schedule out for those in July for the following calendar year. And those 8 meetings per year have been historically scheduled to be in-person meetings. And when we have those meetings, we send out meeting notices as required by the law. And those meeting notices specify, as is required, they specify a particular meeting place so that the public might attend. Each meeting has 2 components. It has a public session component where every matter that is open to the public or discusses records that are open to the public are discussed in the public session. And then we have an executive session meeting, which is where our confidential matters are discussed. And those are usually going to be matters up for probable cause, ethics investigations, where we're investigating for probable cause. Those matters remain confidential until the matter is either dismissed, usually with a no probable cause finding or some other dismissal, or probable cause is found, or if the confidentiality is waived. So if we're talking about something where none of those 3 conditions have been met, it's happening in executive session. The quorum requirements for those meetings, for our meetings, is 5 commissioners. We need 5 commissioners to meet a quorum, so that means 5 commissioners physically present. We need a quorum not just to start the meeting, but for each matter that is going to be voted on. If we start the meeting with a quorum, but then we lose quorum, then we lose the ability to vote on any matters going forward for that meeting. Without a quorum, business cannot be conducted. Discussions can be held, and the staff may update the commissioners, but there can't be any voting or any staff directives derived from voting. All right, so that's normally how we conduct our business, and we do that in an in-person setting historically. There is another method by which we can conduct our meetings, and those are remote meetings, kind of like this one. The State Administration Commission provides rules for conducting meetings by what are called Communications Media Technology, or CMT. And that's in Rules Chapter 28-109. And there's some adaptations to the normal process for holding an in-person meeting to do it by CMT. And the notice requirements still apply. We still have to say where the meeting is being held, except that this notice will say that it'll be held by Communications Media Technology, and will prescribe a particular method for access, either dialing a particular phone number for a conference call or accessing a particular website for a webinar. Instructions will be provided. The other thing that CMT meetings are required to do is where the agency is required to provide access points so that someone who doesn't have the means to dial in or access the website can go to an access point somewhere in this state. Presumably that would be our office, and then be able to view the meeting if they wanted to, if they showed up. Quorum for those meetings, because is again those who are in attendance. So we would need 5 commissioners present for the remote meeting, attending the meeting through the CMT method. And so if we have 5, then we can hold the meeting. In practice, we do remote meetings in public sessions through CMT, like the one today. We did one a year ago to award our first vendor contract for the call center. There are no legal issues with holding a CMT meeting for our public session meetings. Remote, however, presents some challenges, as Kerry outlined. We don't do the remote executive sessions because we cannot guarantee the confidentiality of the proceeding. Complainants are invited, and under the law, they're invited to attend the hearings against the public officers and public employees who they file a complaint against. And there's no guaranteeing that they won't have someone else in the room, potentially a journalist, for example, to listen in on the proceeding while it is confidential, or other people who do not have the right to be in the proceeding or to listen in on the proceeding. So because the commission can't guarantee the confidentiality, we don't do remote CMT meetings for executive session. What this agenda meeting is about, this agenda item is about this, a third option, not in person, not remote, fully remote CMT meetings. What we're talking about is remote attendance to in-person meetings. And you heard Kerry refer to that, and we've been referring to it as hybrid meetings. There are some opinions of the Office of the Attorney General concerning remote attendance by board members of in-person commission meetings. And what essentially those opinions have boiled down to is that remote attendance to an in-person meeting by a member of a board can be allowed in a situation where it's due to medical treatment or physical infirmity. The opinions don't use the phrase reasonable accommodation, but that's essentially, when you read them, that's essentially what they're talking about. If the inability to attend the physical meeting is due to medical treatment or physical infirmity, the opinions say that remote attendance can be allowed in that instance. The other line of OAG opinions on this matter would say that remote attendance to an in-person meeting can be allowed, quote unquote, for extraordinary circumstances. And there's an interesting quote from one of these opinions that says, the participation of an absent member by telephone conference or other interactive electronic technology is permissible when such absence is due to extraordinary circumstances such as an illness. Whether the absence of the member due to a scheduling conflict constitutes such circumstance is a determination that must be made in the good judgment of the board, which leaves it, which makes clear a couple of things. First of all, it makes clear that the law does not create an automatic right to attend an in-person meeting remotely. The board must decide for itself whether or not it wants to allow its members to attend remotely in those extraordinary circumstances. This is a recognition that not all boards are the same, and not all board service is the same, and that the boards are going to govern themselves and how their meetings look. But also importantly, it makes clear that the board decides this issue, not the staff. The staff does not decide whether or not a member gets to attend remotely. As far as quorum in those instances, the way quorum would work for an in-person meeting where members are attending remotely, the OAG opinions are numerous and clear on this point, that the quorum, it means the quorum is obtained by those who are in physical attendance at the meeting. The remote attendees to an in-person meeting do not count towards the quorum. But the remote attendees are allowed to vote and are allowed to participate in the rest of the meeting, in the board business. So in conclusion, it's legally allowed to have remote attendance to an in-person meeting under the OAG opinions. They can do it for medical treatment or physical infirmity or for other extraordinary circumstances as approved by the board. Confidentiality would be preserved in those instances because, again, the member is remote, but the complainants and the respondents, they're present because it's an in-person meeting. The quorum can be maintained as long as those who are physically present rise to the number of people required for the quorum, and voting and participation are allowed. That's my update, Mr. Chair.
Wow. Can you repeat that? You cut out in the beginning. No, I'm just kidding. I'm joking around. All right. So, I mean, going with the agenda, does anybody want to chime in on this?
I would like to just make some
Okay.
comments from Carrie's discussion and Steve's as well. I can tell you the parking at the Senate is not ideal, and accessibility is questionable. You have to go through security. It takes far more time to probably attend a meeting at the Senate than it would where we now attend a meeting, which is easy parking, easy access. And I don't have confidence in the remote item because as I sit here in my house, I've got 5 people here. So a lot of people could be in the remote meeting when it's supposed to be confidential. And there's no way of determining whether or not that is happening, even though Steve had said you could not vote. You would still have people perhaps hearing the discussion, and that discussion can be very sensitive most of the time. That's my comment.
Mr. Chair, I was just going
Thank
to
you.
want to
Go
thank
ahead,
you
Commissioner
for putting
Rogers.
this on the agenda and waiting till I was at a time when I could participate. As I was sharing with Senator Stewart before the official meeting started, when she said she had a long ways to go to get to the capital city, and that this arrangement beat her having to make that drive, I pointed out at Naples is even further away. So thanks for getting us on the agenda, and staff, thanks for your attention to detail as always.
No, thank you, Commissioner Lau. I just rather have it when you're here present so we can get some meat on this. Does anybody have any other comment, discussion, or points they'd like to make on this agenda, on this item?
Hey, Mr. Chair.
Go ahead, Commissioner Rogers.
Hey, thank you, Mr. Chair. Yeah, from my standpoint, this is my first meeting. I want to get comfortable with the commission, and for someone just coming on fresh to this is kind of a big item to say, are we going to change the process that's been followed for decades? I live in town, so it's a convenience factor in some ways, but I also travel a lot for work. So in many ways, that it could be beneficial to be able to attend remotely when needed. I would just want to spend a little bit more time in this role before I weighed in on this, or at least weighed in favor of allowing remote. But I'm not opposed to bringing it up at a later time. I'm just so new that I'd hate to change the rules on my first day.
Okay, understood. Thank you, Commissioner Rogers. Anybody else have any comments? Well, I think I made this known the last time, and I think maybe now, with the exception of Commissioner Hellman, depending if he lives north of me or south of me, I think I'm the one that travels the most, only because I'm almost not even in Florida, to be honest with you, when you look at the state. But and for me, it's an inconvenience. I mean, I have a practice, I got young kids, but I enjoy I don't know about the word enjoy, but just from my procedural standpoint, listen, I benefit from Zoom hearings. I do them all the time. But in the context of this, what we're dealing with here, like either A, let's take a look at more options or something like that, or B, I'd rather keep it like this for the time being until maybe something maybe easier that can facilitate these type of meetings presents itself. I know technology is changing all the time, and that may be something that we look at. But for right now, based on the confidentiality and just the ease of with we have access to the first DCA, Commissioner Rogers and Commissioner Hellman. I know you've never been there, but it's extremely catering to our needs. The meetings go by very quickly. We're able to get the audience members in and out, and it flows quite nice. It also gives individuals an opportunity to be there. I mean, I understand that we're moving towards an age of technology. I embrace it fully. I benefit from it, to be quite frank with you. And a selfish perspective, my family would love the fact that I would be remote. 24 hours in Tallahassee is not really my idea of a getaway. And nothing against the people in Tallahassee, but that's my position. It's more from an integrity. Maybe it's a reflection more of my age or something like that. But I maybe we should not close the door completely, but maybe have staff research it as it unfolds. But for right now, my position will be to keep it as it is. Thank you. Any other comments? Nope.
I think Commissioner Stewart's comments about how many people she has where she is are well taken. If I may make a suggestion, Chair, we could explore providing secure locations that are remote in nature, allowing people who do not want to make the trip to appear in a location that we can guarantee is secure. That is just the only the persons who are allowed to attend are in that area. We could also explore some type of certification or sworn statement that is provided for anyone appearing remotely that they are who is attending in that remote attendance. So that it would be some type of a sworn statement as an affidavit or something of that nature. Just alternative means to assure that the confidentiality is kept without, that I think we have to consider that, technology is going to continue to progress. And if we want to hold on to our tried and true methods because they're tried and true, we're just we can't bury our head in the sand. We have to acknowledge that that we have to come up maybe with some other alternative. I also recognize you know that there are costs associated with these changes. At the same time, we could possibly survey the expense that we go to each month that we have a meeting. I mean, just if you're spending, you know, $500 to $1,000 just to get a commissioner to go to attend the meeting. I mean, there's you know, plus the cost of moving everybody over to the first DCA, and you're looking at anywhere from $5,000 to $10,000 every time we have a meeting. So there's a balancing that can certainly be considered to justify maybe exploring further some rule changes or some statutory changes that would allow for technology to be considered.
Thank you, Commissioner Bain, for those comments. And I agree. I think the first step, if it were to happen, which I think is inevitable, it's a matter of time. I agree with you. Is the hybrid meeting would be the first logical step where the commissioner appears remotely, not the respondent or the complainant. In other words, so the confidentiality. Listen, if we have a hard time getting people to hit them with fines, can you imagine having them sign a confidentiality and there's a breach? I mean, we'd have to like legislate all that. But all kidding aside, I agree with you 1,000%. If that's even possible, that you know, if you're not moving with the times, you're going to be left behind. It's just gonna, it's what's going to happen. But for right now, I think staff could maybe look at some options on that. I agree 100%. Thank you.
And Mr. Chair, if I can just comment on the comment about the confidentiality. I don't think the commission staff takes mobile devices away from people in the audience when they enter the courtroom. Do they, General Counsel? You're allowed to carry your phone in there, right?
That's correct.
Okay. So, I mean, I hear a concern, but everybody that steps in there and sits out there and has a phone or a watch and with modern technology can be recording the meeting anyway. You know, the part that they're in for, I'm talking now about the private sessions where just the party against whom the proceeding is taking place is allowed in the room.
Understood. Was that a
I
question?
think that was for you, Steve.
Oh, I'm sorry. I didn't understand that to be a question.
He answered it.
Oh, okay. I will add, I think that the confidentiality issue is maybe separate than what the agenda item is, where the agenda item is not that the parties are attending remotely such that confidentiality would be breached. The parties would still be attending in person. My understanding is that the request was that a member of our board would be attending remotely. And that I don't see that. What I tried to lay out in my remarks was that confidentiality is not a concern in that instance because, you know, presumably a member of our board is in control of their own environment and domain and understands that we as an agency are bound by the confidentiality rules and would act in the agency's interest there. So I'm not, the confidentiality discussion is only really a concern when we're doing remote executive meetings, which I don't understand that anybody to actually be proposing here today, and unless I've misunderstood.
I think since that was a general part of the conversation overall and from the last meeting, I think that's what Commissioner was referring to, even though today is more of a hybrid approach, meaning allowing one of the commissioners. But listen, I think we've had this discussion. We may not be here, and not that I'm leaving anytime soon, but I think inevitably, most, if not a lot of the hearings are going to be remote. I mean, we have the problem down here in Dade County where they spent, I can't tell you how many millions of dollars in a courthouse, and they're having a hard time getting the judges to go back to the building. That now all the judges are used to remote hearings, so it's a learning curve that everybody's going through. We're not the only ones in isolation. Commissioner Lucas, you have is that your hand raised from before or now?
now. And I spoke about this like you did, Chair, a few meetings ago, so I'm not going to belabor the point. My only thought, and I agree that there's an inevitability factor to all of this. I think my only concern would be that if we're going to extend to ourselves as a volunteer board of, professionals, a convenience to not travel, that we should extend that same convenience to the individuals who are compelled to appear before us against their will, facing, pretty serious penalties, and many of whom are just may not have the same resources as some of the people sitting here have. And so I would just think that the convenience and the courtesy and the inevitability, to be fair, should run both ways. So maybe that's something, and I know that's, sorry, Steve, outside the scope of the agenda item, but I just think it's something in the future, whatever future constitution of this body makes the ultimate determination, it's something that should be considered for both sides to be able to take advantage of any sort of benefit like that.
All right, excellent point. Excellent point. And Commissioner Bush, you have a comment to make or
Well, I will just say that it's inevitable that remote will be the way of life in the future, whether it's immediate or in the not too distant future. We need to take that under consideration. However, when it comes down to the confidentiality, unless it costs you something, then there's no way that you can kind of monitor that. If costing meaning that if you violate it, there's a penalty. And I think coming in, we need to keep it the way it is so that we can get to, communicate with the new members and let the adjustment period takes its roots. And then in the future, because I believe it's inevitable that this is going to be the way that business will be conducted, not only in politics, but all aspects of our lives. So I'm in favor of leaving it the way it is right now, but continue to explore different avenues and ways of how we can eventually adjust to the technology.
All right. Thank you, Commissioner Bush. Not to throw you under the bus, but Commissioner Hellman, you have any comment, too late. You're under the bus already. So
Like Chair Fuste said, I think I may be a little further south than him. But I don't, this being my first meeting, I really have no strong feeling one way or the other. So as Commissioner Rogers said, I'd kind of be willing to wait a little bit and play it out, and then kind of, if anything pops up, go from there.
thank you. Thank you very much, Commissioner. Welcome aboard. All right. Does anybody have any other comments? Okay. I guess it's a good time for a motion to adjourn. I mean, we don't have any action on this, correct, Steve or Carrie?
Looks like Commissioner Lyle has one. Looks
Yeah.
like he's getting ready to say something.
Okay. Go ahead, Commissioner.
Just a housekeeping item. We moved on to the second agenda item more quickly than I thought we were going to. I had thought that the first issue was really just dealing with the appellate issue and didn't deal, and maybe that's all we have to deal with. I guess I expected a second part of that discussion, and it might be very brief at this point, in terms of waiving the fine. But if you got, General Counsel, if you had all the business done you needed to in the minutes, I'm fine with that. I just didn't want to not have addressed that if you go back and look at the motion.
My understanding was the motion was to approve the recommended order, which does not only waive the fine, but it also rescinds the prior default final order. What will happen from there, and if Gray's still on, he can correct me if I'm wrong, but what we're going to do from there is we're going to provide the status update to the court as the court ordered us to do. And then I suspect that we will pair that with some sort of a motion to dismiss the matter.
Dismiss is moot.
Yeah.
Okay, thank you. That was it.
You're welcome.
All right. Thank you, Ms. Lau. All right. if I can get a motion to continue, I apologize.
Motion to adjourn.
Earn.
Motion to adjourn.
Motion to adjourn,
So
first,
moved.
second?
Second.
All right, hearing any opposition? Here we go, thank you, guys.
Thanks
See you
all.
in a couple of weeks, Tallahassee.
Take
Bye.
care.
Take care.
Okay, take care.